I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this series on state public record laws and the Federal Freedom of Information Act. These lessons are brought to you by NEFAC with help from the Society of Professional Journalists Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. Each lesson is a continuation of previous classes, so if you haven't already, please visit nefac.org/FOI guide. You'll find there a growing library of video tutorials and other freedom of information resources. Thank you again for joining us. Now here's NEFAC's Emily Sweeney to introduce you to our instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you for joining us for this webinar, which is part of our ongoing series on public records laws. This session is going to focus on the appeals process and what you can do when your public records request is denied in New Hampshire. And with us today is Greg Sullivan. He serves as the General Counsel for the Union Leader Corporation. He also teaches First Amendment media law at Suffolk University Law School in Boston and at the Naki Loeb School in Manchester, New Hampshire. So Greg, thank you so much for joining us today.
Hi, everybody. Thanks for being here. Unfortunately, the appeals avenues in New Hampshire right now are extremely limited. In fact, I want to talk a little bit about how to avoid having to appeal a denial of your public records request. Because in New Hampshire, the relief that you're going to try to seek is only in the Superior Court, which the average citizen may not want to go pro se, and they may not want to hire a lawyer for two different reasons there. You know, one is expense, and one is a lot of people aren't familiar with the court system, are nervous speaking in public, etc. So what I'd like to do is share some slides with you all, backing up, first of all, to our right to know what the government is up to. Where does that come from? There's only probably 4 words that you can read on this slide. This is the Constitution of the United States. And the 4 most important words to me, they made them big enough for us to read even without our spectacles on. And those 4 words are "we the people," and down at the bottom, "done." And I use that slide to make the point that we the people are the government, own the government facilities. We own the White House, the State House, City Hall, etc. Oh, there we go. So we call this the right to know what our government is up to. Again, our government really is us. Here in New Hampshire, we have 2 constitutional provisions, and this first one, Part 1, Article 8, it's not unique, but we're only one of a few states that enshrine our right to know what the government is up to within the Constitution. I'm going to have to blow through these slides rapidly, but I will, at the end, give you all my email address. I'll be glad to send out slides or answer questions that we don't have time for this evening. So Part 1, Article 8 says, all you government employees are working for us, the people. Government, therefore, should be open, accessible, accountable, and responsive. The public's right of access to governmental proceedings and records shall never be restricted. No, wait a minute, that's not what it says. Shall not unreasonably be restricted. So that's the key. Word pretty much under all law is reasonableness. Part 1, Article 22 of the New Hampshire Constitution is even stronger than the First Amendment, which we also move for government records under. Free speech and liberty of the press are essential to security of freedom. They ought therefore be inviolably preserved. As I say, that's even stronger language than the First Amendment itself. A guy named Jefferson said, if I had to pick between newspapers and the government, I'd pick the newspapers. And when we limit our freedom of the press, we lose it. But there are conflicting and crashing, as you can see, our First Amendment right to know rights are that colorful train, and the other train that crashes and clashes head on with those rights are other governmental and societal interests. And they include, most commonly, national security, public safety, protection of children, protection of reputation, and privacy, which is a big one in the right to know field. So this is the preamble to our right to know law in New Hampshire. And again, it kind of reiterates what the Constitution is saying, that openness in public business is essential for democracy. This law ensures the greatest possible public access to the actions, discussions, and records of all public bodies and their accountability to the people. Very strong. It goes on, and here's some advice for people who are having difficulty getting governmental or public records. Get Chapter 91A on your computer if you can, or go to the library and copy it, but have 91A with you when you're writing your request. And I say writing because that's step number one, that often people make a mistake. They might make a telephone call or go into town hall and have a conversation and think that's a valid request, and it is. But if you're denied, it can be a he said, she said. That's not what they are asking for. And we had a case I'll talk about momentarily where the city was withholding records saying that 5 Keene State University students had been asking for lists, and when the Supreme Court looked at their request, there was nothing in it about requesting a list. So look at 91A, learn as much about it as you can. And I'm going to go real fast through these slides so we have time for questions later on. If they maintain the records in electronic format, they can give you records. They can email those records to you, as long as it does not reveal information which is confidential under 91A. Every citizen has the right to go in and request these records. Again, my advice is do it in writing, and not just do it in writing. Make sure you keep a copy for yourself. Of course, email these days is making that less important. When I was doing this work initially, many years ago, you had to use a copy machine to make a copy of your written request. Here's an important one, because we have public employees leaving their jobs sometimes unexpectedly. People want to know why. Sometimes employees are terminated. They either threaten to file a lawsuit or they file a lawsuit, it's settled, and the municipality and the individual enter into a confidential settlement agreement. They can't do that. They do it, but you then have the right, based upon 91A, to say, no way, I want to see that settlement record, and they must be made available. Public meetings, they have to keep minutes, they have to keep them open to you, but the name of the game in this field, as we're going to find out, is the exemptions. And here is 91A4, Roman numeral 4, saying they have 5 business days to give you the records you're asking for, or deny your request in writing with reasons. And a lot of the reasons are very vague. So a point I want to make about not having to appeal, not having to go to court, is schmoozing is the word to me. Whether it's on the phone, whether it's in emails, or even better in person, when they deny your request, try to get more specific reasons from whoever you're dealing with behind the counter, because sometimes they do have a valid reason, but you can easily, once you understand that reason, refine your request, make it more specific, or an important thing to remember, it may be on a slide here, I'm not sure, is that if the government doesn't keep a record in the form that you're looking for, they do not have to give you, they don't have to create any records for you. That's, again, every agreement to settle a lawsuit against a government agency has to be kept on file for 10 years, and we have the right to look at it. And this is what I just mentioned, is they don't have to compile, cross-reference, or assemble information into a form in which it's not already kept. And that's something really to keep in mind when you're making your request, because once you ask for something, if you ask for a list, for example, and let's say you're going to a police department saying, I'd like records relating to the excessive use of force by your officers in the last 5 years. That's fine. And you have a right to those records. But if you say, I'd like a list of all the instances of excessive force, they don't keep a list and they'll deny your request just saying we don't have those records, which is, leaves you scratching your head, which again, the kids at Keene State University who took their case all the way to the Supreme Court and prevailed, they didn't ask for lists, but the city kept saying, we don't keep lists like that. The name of the game in this field is the exemptions. And when I say print out 91A5 and look at it, it's really going to help you tailor your requests so that they're not denied. And this is the big one that you find in courtrooms in New Hampshire every day. Records pertaining to internal personnel practices, whatever the heck that means. And if you read this literally, confidential, commercial, or financial information is exempt. It's like, wait a minute. The legislature gives this public agency $1 million, and we'd like to know how it's being spent. No, that's financial information. But the Supreme Court has ruled that that's not a categorical exemption. What the court is doing more and more, the Supreme Court, and instructing the lower courts to do is balance the public interest in the information that's being requested versus whatever privacy rights might attach to those records, whether it's a third party's privacy rights or a governmental official's privacy rights. We're now going to balance. Back in 1993, the Union Leader Corporation was trying to get records from the Dover Police Department. They had heard that one of the officers was being disciplined for misconduct. And the police department said, no, that's an internal personnel practice. And the Supreme Court of New Hampshire agreed in 1993. In 2020, May of 2020, that case was overturned. And in two cases on the same day, and the City of Keene case, all three cases were argued on the same day and decided on the same day. And the court said internal personnel practices is not what we've said it was for the past 27 years. It's far more specific, and investigation of misconduct in a police department, or for that matter, any governmental agency, is not an internal personnel practice. There still has to be a balancing test, but when you're trying to get information about the behavior and the conduct of public officials, we have the right to know, not their private lives, but their official duties. So financial information, for example, in Mans v. Lebanon many years ago, the Supreme Court ruled we have the right to find out about the salaries of governmental officials. More recently, in the 2000s, we got the right, Union Leader versus New Hampshire retirement system, to get information about pensions that people were getting. So dropping down in Roman numeral 4, we come to and personnel, medical, welfare, library user, and this is the big one, other files whose disclosure would constitute invasion of privacy. The Union Leader, was looking for a video of an individual who had been arrested. His case was dropped. A police officer had said that was a political bag job. Union Leader, he said, and I can prove it because I videoed that arrest, and the video's at the station. It was a charge of drunk driving, which was dismissed on the first day, the day it was scheduled for trial. So the Union Leader reporter went to get the video, was denied, went to Superior Court, denied, and the Supreme Court ruled if the information will shed light on the performance of a governmental actor or agency, the privacy right will take a back seat. Some of the exemptions, and you need to know the exemptions so you don't make requests that aren't meritorious. Some of them are very common sense: teacher certification records, computer files, examination questions, and again, here's public safety, how we carry out emergency functions. We have the right to keep that private if disclosure would interfere with the ability of the agency to combat the evil that the government is trying to suppress. Preliminary drafts and notes, we don't get them unless it's circulated to a quorum of the public body. There are statutes like this one, employment security, where by statute, these records are confidential. Coming to what I'm supposed to talk about, the appeals process, as I think I've already said, we don't have a good appeals process in New Hampshire. Connecticut has a wonderful commission where if you're denied, you can go to this commission and get pretty fast relief if it's appropriate. Massachusetts has a supervisor of public records who you can bring your request to if it's been denied. But in Massachusetts, the supervisor says, yes, city, you've got to give over those records. If the city doesn't want to, they don't have to. You've got to take them to court. So that's not a good model. There is a bill pending in New Hampshire to create what's called an ombudsman. And again, if your request is denied, you might not be able to afford a lawyer. If this ombudsman position is created, it's being debated in the legislature as we speak, that's going to be an avenue of appeal that we now do not have. My concern is, as drafted, the law says, if you go to the ombudsman, you cannot file in the Superior Court. And I'm thinking, okay, they set up this ombudsman, he's inundated or she's inundated with 5,000 requests. There's going to be a 2-year backlog, but I can't go to court because I filed my request with the ombudsman. And that's my specific opposition to that particular bill. If they violate the law, you have the right to have your attorney's fees paid, and your costs, if the agency knew or should have known that they were violating the chapter. Doesn't happen with frequency, but it does happen. And conversely, if your request is deemed to be bad faith, frivolous, unjust, vexatious, wanton, or oppressive, the city or town or the state can get an award against you for their attorney's fees, which might be very significant. Court can, if a public body violates the law, the court can vitiate or take away what they've done. Again, I don't have time to go through all of 91A with you, but I suggest you do it. Get it, read it, understand it, and that way you'll be able to have the type of conversation with the person on the other side of the counter or the other side of the desk that hopefully will lead you to a compromise if appropriate. And if not, right now, you take yourself to court, which is not all that difficult to do. Sorry, all the lawyers out there. But it can be pretty simple. You just sit down and write. You can do it with a pen and ink, saying, this is the request that I made. It's attached as Exhibit 1. This is the denial attached as Exhibit 2. I believe it's a violation of my right to know. Sign it. It can be that simple. And the court will entertain you. And under 91A, cases like that are entitled to preferential treatment or a speedy trial. I have to look at the clock just for a minute, talk about law enforcement records, because if you went back and looked at that exemption I showed you, you would notice that law enforcement records were never mentioned, which I think was an omission at the time. And back in 1979, the Supreme Court of New Hampshire said, oh yeah, so what we're going to do, we're going to look to federal law. This is 5 U.S.C. 552, Exemption 7. Says that law enforcement records are exempt, but only if the production will interfere with law enforcement proceedings, will deprive a person of a right to a fair trial, will constitute an unwarranted invasion of personal privacy, disclose confidential sources, etc. It's pretty common sense. This one I'm not crazy about, disclose techniques and procedures for law enforcement investigations, but or endanger the life or safety of any person. Any affidavit they file in court, and by the way, court records are not subject to the right to know law. The office of the governor is not subject to the right to know law, but those agencies are subject to Part 1, Article 8 of the New Hampshire Constitution. So if you're dealing with court records, you don't say, I want them under 91A, I want them under the Constitution. Affidavits in support of arrest warrants, for example, are deemed by statute public records that we can get. All court records, unless there is a real competing, countervailing, significant interest, court records are open to us. And this is a key word. When the official says to you, I'm not giving you the record because it is exempt, you need to say, well, wait a minute. It's called redaction, but I like to say redaction and spell it for colorful the letters. Wait a minute. Are you saying every the, of, and of that document I can't see? If there's something that is properly exempt or private, they can white it out, black it out, redact it, and you can demand that. Well, when I say demand, of course, I'm trying to say that you get more with sugar than you do with salt when dealing with these public agencies. But certainly if they're roadblocking you, you can say, well, wait a minute, can't you redact any portion that we're not entitled to get? It's a huge part of the litigation that happens is judges determine what needs to be redacted and what doesn't need to be redacted. Hey, I'm out of time, but I got to tell you, everything you need to know in the field of accessing public records is available on the Reporters Committee for Freedom of the Press website, rcfp.org. And I wish I, excuse me, had a slide that said, this is my email address. I normally do, so I'm going to have to just say it, which is g.sullivan@mslpc.net, or you can write to Justin Silverman at New England First Amendment Coalition, and he'll forward any requests to me. But I'm glad to field questions now or later via email or telephone.
That was really enlightening, Greg. I didn't realize how many exemptions there are, especially, so many broad exemptions, like financial and commercial. It's kind of scary.
Yeah, that's I know, but it's not enforced. There's always a balancing test. And I got to tell you that New Hampshire is very limited in the exemptions, thank goodness, because take a look at the Massachusetts public records law. It goes A through V, I believe it is. And Vermont has something like 265 specific exemptions.
Yeah.
It's bad. Rhode Island, lots of bad exemptions. Connecticut is really a model, as I said earlier. They have this commission that knows their right to know law. They call it the Freedom of Information Act, which is what we call it in the federal system as well.
We have a question here. Well, one person was just thanking you. And then another question is, what about requesting records/video from prisons after an attack?
When you say after an attack,
I'm not really sure.
Going back to governmental interests that will allow for secrecy, one of them obviously is public safety. So, the administration of a jail or a prison is going to say, oh no, if we ever let that video out, you'd be able to see how we do things, and and you'd fight it. And you might get a portion of the video, there might be some redaction necessary to protect the public safety and the security in the jail, but certainly our rights to get information in jails and prisons is not the same as we can get at City Hall, for obvious reasons.
And we also have two more questions that just came in. Frank Ferraro was asking, want to know, have you testified on the omnibus bill?
I wrote a letter, which is written testimony, pointing out the things that I felt really needed to be amended, and which was the big thing, as I've already mentioned, was if I'm stuck with my request to the ombudsman and there's no daylight, no sunshine at the end of that tunnel, I can't file in the Superior Court according to this proposed statute. And that's just not right to me. Justice delayed is justice denied, particularly oftentimes when we're dealing with a timely subject, such as a attack in a prison.
We also have another question from Johnny, who wants to know, he has a question about release forms. Are there any situations in which cities in New Hampshire have the right to require requesters to sign release forms as a condition of receiving public records?
Not even close. Never heard of such a thing attempted. Never mind trying to, defend it, because that's just not, we the people have the right to know what our government is doing and is up to at all times. That's Part 1, Article 8 of the New Hampshire Constitution. We don't have to give up any rights to use those rights. And I want to say one thing about Part 1, Article 22 in the First Amendment, because they don't talk about the right to know. They talk about free speech and free press. But I say that the rights to free speech and free press are eviscerated or diminished without a corresponding right to know what the government is up to.
Greg, thank you so much. Really appreciate it.
Yeah, I will just, Emily, in closing, say it's really difficult to cover a field like this in less than 30 minutes. So take a look at the websites of both New England First Amendment Coalition and the Nakias Loeb School, where classes delving into these issues are free. Historically open, but last couple of years, of course, we've had to do them virtually, but it looks like we're opening back up to in-person classes.
Okay, and actually we have one more last minute question. Do you mind taking one, Greg? Is that okay?
I'm not in a hurry.
Okay, this will be the last one though. But it goes back to those consent release forms, which I've never heard of being used either. Johnny said, that's good to know. And he says, I think I know the answer to this now, but are there any situations in which cities in New Hampshire have the right to make requesters liable for lawsuits that are related in any way to the requester's use of the public records? This has been suggested in a release form that I just received.
Yeah, I don't know anything about a release form, but one of the slides that we blew through quickly said that yes, a city or town or the state can get their attorney's fees back from a requester, but only if the request is frivolous, made in bad faith, which, is hard to envision. I've never heard of it happening.
Greg, thank you. This was really enlightening. And yeah, hopefully everybody tune in for the next one. All right.
Thank you, Emily. Thanks, everybody.